Uh, all right, we have a very special guest with us today to talk about special needs planning. Carlos Aguila. He is down. He's an attorney down in the South Florida area. He is committed to safeguarding the loved ones of those with special needs. He is passionate with estate planning, and you're going to hear all about everything from special needs trust to guardianship. You'll hear a little bit about why he chose to go this route and why it's personal to him. He also is very fortunate to be working with his wife, who is a speech pathologist as well, serving this community at large and really trying to respect all individuals' rights despite our various exceptionalities. So, Carlos, welcome.
Thank you, John. Happy to be here. Excited to speak to everybody about this area of the law that's, as you said, is a particular passion of mine.
Awesome. Well, we'll give you a quick rundown. So if you haven't heard about ABLE program, we'll go ahead and launch that poll real quick about have you even heard about ABLE accounts? And if so, just go ahead, put your answers in there. It'd be good to see some feedback. I know we're going to have quite a bit of participants today. Awesome. And some of you might have even been with me on a training with the Agency for Persons with Disabilities last week. So let's see, give everybody a few seconds to answer here. Awesome. So it looks like the results, about 90% of you have heard about ABLE accounts, which is great. So you're going to hear a lot about how special needs trust tie into ABLE accounts, but just high level. An ABLE account is a tax advantaged savings and investment account specifically designed and advocated for and on behalf of individuals with disabilities. It allows individuals to put funds aside that those funds can grow tax-free and then be utilized for a variety of qualified disability expenses without negatively impacting public benefits like supplemental security income or Medicaid. So it's a pretty amazing program. I encourage all of you to check it out, or if you're supporting individuals in this community, to definitely see how it may benefit them as well. Now, just some housekeeping rules. This is being recorded, and so keep that in mind. If you want to go back and view this at a later date, we'll be able to upload it to our YouTube channel. We also encourage you to use the Q&A section to answer your questions. We'll do our best to answer them. We have a couple of individuals from our team on the back end that will be answering those questions, and then hopefully we'll be able to answer some of those questions as live as well. But now at this time, Carlos, I'm going to turn it over to you to kind of run through your presentation, and appreciate you being here today.
Thank you, John. Appreciate the invite, and I'm happy to be here today with everybody. I'll go ahead and start my presentation. So good afternoon, everybody. My name is Carlos Aguila. I am a South Florida attorney located in Miami, Florida, and the founder and owner of Aguila Law. Our office is dedicated in assisting families in the areas of guardianship, probate, estate, and special needs planning. Now, the reason why I love talking to everyone about special needs planning is because it is a particular passion of mine, because I am a proud uncle of an individual with autism. I put up on my screen some photos of my niece and goddaughter, and this is why I do it. I do it because we found that, particularly in South Florida, there is a lack of information and education out there for families with loved ones with special needs regarding special needs planning and also guardianship. So really, my niece is the reason why I do what I do. So anytime I have an opportunity to educate families, I'm all in. So I'm very happy to be here and excited to present to all of you. So the title of our presentation is Special Needs Planning. Planning for the future your loved one deserves. Now, just by way of quick disclaimer, we are going to be discussing legal topics today, but please note that everything that we are talking about is for educational purposes. Special needs planning, guardianships, estate planning, these are all things that are very individualized. So I highly suggest that if you do have a specific issue, you do discuss it with an attorney. Okay, so with all of that being said, let's go ahead and get started. So what are we going to be discussing today? Of course, we're going to be talking about special needs planning, but first I want to start off with what exactly is special needs planning? Okay, and then we're going to talk about why we should plan. What are the different steps we can take to begin developing our special needs plan? Then we'll briefly discuss public benefits, and we'll talk about the different types of public benefits that we should be considering when we're developing our plan. We'll get into special needs trust. We'll talk all about that. Of course, we'll talk about ABLE, and then we will cover guardianship. So a lot of things that we're going to cover today, and hopefully this will all provide all of you a lot of information and education to help you with your plans. Okay, so what is special needs planning? So I have up on my screen what I think to be a very good definition of what special needs planning is. And I'll go ahead and read it. It is a legal and financial process to assist people with disabilities in meeting their needs and preparing them for the future, including the preservation of public benefits. Now, notice that at the end of the definition, we say including the preservation of public benefits. And that's important because, yes, special needs planning is by and large involves public benefits, but it's not the only thing. And I think that that's important for everyone to understand. Special needs planning, yes, it has the public benefits component, but really it is life planning. It is about making the determination, thinking about all of these things so that we can ensure that we are putting a plan in place that is going to provide your loved ones with the life that they deserve after mom, dad, caretaker have passed. That is what special needs planning is about, including the public benefits, but also life planning. So that's what it is. Why do we plan at all? And the reason why we plan at all, I've highlighted on my screen the things that I think are important about why we plan, is because we want to maximize the quality of life of our loved one with special needs. It's important that we do this in a way that provides protections. However, it's only those protections that are necessary. Because when we are planning for their life, we want to make sure that we're not only promoting their independence personally, but we want to make sure that we are promoting their independence financially. And that's why we plan. We want to develop a plan that ensures that we can, that they can have the life that they deserve well beyond after mom, dad, or caretaker have passed. So we want to do this in a way that ensures their safety and well-being so that we can go ahead and enhance their quality of life and promote their independence. So that's what it is. That's why we plan. Let's talk about what are the benefits of planning. All right, so on my screen, I have what I think are the benefits of putting together a special needs plan. So you'll hear throughout the presentation that we're talking about financial security for our loved ones, for preparing for that when you as a family, as a parent or caretaker for an individual with special needs is no longer here. And we want to do that in a way that ensures that we are maximizing means tested public benefits. Okay, so we want to make sure that our loved ones can take advantage of those public benefits that are out there for them that they are entitled to, but do it in a way that they are not solely dependent on these public benefits. And we want to do that to ensure that they have that life that they deserve well beyond your passing. Now, as I said, it's not just about public benefits. It's also about a variety of other things. It's life planning. So when we put together a special needs plan, we're talking about and we're implementing a plan that appoints a proper team to provide lifetime management. It's not just about public benefits. We want to put in place, we want to document who's going to be the team of individuals that are going to assist our loved ones with special needs when we're no longer around. We want to plan for housing. I know that's a big concern for families, for parents. You know, They may have a plan. They may know exactly where their loved one is going to live when they're no longer around, but maybe they don't, right? So with putting together a special needs plan, we can plan for that. And maybe right now we don't know. Maybe right now we don't know what that ideal housing situation is going to look like, but maybe we can think, maybe we do know already what would be unacceptable. And maybe there are things that are unacceptable for you, and we can document that. We can put that in as part of your plan. We want to plan for caregiving needs, right? We're going to consider what are the needs of our loved one? What are they going to continue to need? What sort of services they may continue to need? We want to be able to document that and make sure that there's a plan in place for that. We can do that with a special needs plan. We want to protect beneficiaries from predators. What does that mean? Well, if we're leaving behind assets for our loved ones so that we can maximize their life, we want to make sure that it's done in a way that you know individuals will not attempt to take advantage of them, right? And we can do that with proper planning. We can ensure that people that we name are making sure that the beneficiary of these assets, beneficiary of the money that we've left for our loved ones, is not being subject to predators. We can preserve assets for heirs, and really it's about providing an ongoing system of advocacy for our loved one. Okay, great. So that's what it is. That's why we should do it. The benefits about special needs planning, why I think it's important to have it. So what are the steps that we can take to start building our special needs plan? Well, first, you have to begin to think about your loved one's future, right? This is future planning. What does that future look like? What sort of life do you want your loved one to have when you're no longer here? Right? What kind of lifestyle are they already accustomed to? Maybe they enjoy traveling, they enjoy shopping. We work with families that their loved ones love going to Disney World. Um, we can think about that and we can consider, all right, well, what is that life going to look like when mom, dad, caretaker are no longer here? Then we got to think about financially. What is it going to take to be able to provide that life for our loved one? And then consider whether or not public benefits should be included as part of our overall plan. I can tell you that public benefits should be, right? It's something that we definitely want to be incorporating as part of our special needs plan for a variety of reasons that we will be discussing. So once we've gone through these steps, through this analysis, then we're going to begin to think, okay, well, have I, as the parent, caretaker of a loved one with special needs, have I myself prepared an estate plan? And if I have, has that estate plan or does that estate plan accomplish the goals of providing that life for our loved ones with special needs? Okay, and then we need to consider, is our loved one going to need a guardianship? Right? And we'll talk about that. Not everybody needs a guardianship. And we'll talk about the different things that we need to be thinking about as our loved ones approach the age of 18. Okay, great. So let's start doing it, right? I've got some questions on the screen that we can start thinking to help sort of begin considering, our plan for our future our loved ones' future. Let's start. Where will they live? Okay, as I mentioned earlier, that is a big concern for parents. Maybe they don't know, or they do know. Maybe they know that they would like their loved one to reside at a private residence with someone that they know, someone that's already very involved in their loved one's life, and that would be an appropriate housing for their loved one. Okay, what type of level of care do they need? Okay, we can document all of these things so that it's clear, so that it's understood that this is what they need in order to have a fulfilling life. Talking about lifestyle again, okay? We want to make sure that this plan maintains the lifestyle that they have and maybe even creates a better lifestyle for them, right? Because we want to make sure that it is a life that they deserve. And so we can consider their current lifestyle. We want to make sure that this plan, yes, it is taking advantage of public benefits. However, our loved one isn't going to be solely reliant on public benefits. As many of you may know, public benefits are simply not going to be enough to be able to have the life that we want for our loved ones. And then, let's consider future challenges. That could look like a variety, it could be a variety of different ways that there may be future challenges. It can look in different ways. Maybe there is a family member or someone that we don't want our child to be involved with. We can document that. So we want to be considering, are there any future challenges that are important to be documenting in our special needs plan? Okay, so how do we get there? What steps do we need to be taking? Well, one thing that I always recommend to families are to, consider working with a financial advisor. Um, they are professionals that really will know what it's going to take financially to stretch out, right, that life for your loved one financially so that we can ensure that when you're no longer here, your loved one with special needs, will have the resources, the financial resources to be able to live that life that they deserve. Um, you know, Oftentimes we recommend financial advisors that are very well versed in the community. They understand special needs. That's the type of advisor you want to be looking for, someone that understands special needs, understands what it's going to take, okay, because they're going to be the ones that are going to best guide you in what it's going to look like in order to stretch out financially for your loved one with special needs. Have you considered expenses of living? Right? So we need to be thinking about that when we're working through what it's going to take to be able to design that life for our loved ones. We got to think about expenses of living. Maybe you have a home already that you're planning for your loved one to reside at after you've passed. Well, have you thought about what it's going to take to run that home? Okay, so we have expenses associated with the home, like things like property insurance. We have property taxes, even things as simple as maintaining appliances. These are things that are financially things we need to consider. It's not just about having the home, but it's about the maintenance of the home. Have you opened an ABLE account? ABLE is something that I recommend to all our families. To me, it is an absolute no-brainer. It is a great way to not only provide additional resources for our loved one with special needs in a way that doesn't jeopardize public benefits. It also promotes their human dignity. Why? Because now we are putting aside money that belongs to them, uh, in addition to any other money that we have in a special needs trust. And it's their money. It's their money that they have, and it doesn't count as a resource for with some exceptions that we'll talk about when we're talking about qualifying and maintaining eligibility for public benefits. And then, do you have an estate plan? And do you have an estate plan that includes a special needs trust? Okay, so many people have an estate plan. They've maybe put one together, and maybe they didn't put together a special needs trust. That's something that you need to be thinking about, because in order to have that full comprehensive special needs plan, you certainly want to have both an ABLE account and you want to have a special needs trust. So I've been talking about special needs planning. I've discussed estate planning. Let's just make sure that everybody knows what estate planning is. So what is estate planning? So when we think of estate planning, people may think, wills, trusts, leaving assets behind, making sure that people that we love are receiving the property that we've left behind for them. Estate planning deals with the two inevitables of life, right? Death and taxes. I mean, it's no shock to anyone listening, right? We're all one day going to pass. And we want to put together a plan on how our property is going to pass on to our loved ones in a way that that's smooth, that involves little court interference, and gives access to gives these assets to our loved ones immediate access. But we're also thinking about incapacity. Okay, so if you are a parent of a minor, and God forbid something were to happen to you and you become incapacitated, you're not able to make decisions for yourself or decisions for your minor child. With an estate plan, we can designate people. We can designate decision makers, people that we know, love, and trust that can come in and make these decisions not only for ourselves, but also for our minor children. Okay. State planning can takes different forms. We can develop a will-based plan or a trust-based plan. Really just depends on your individual circumstance. Um, and so, why is it important? Well, it's important for the reason I mentioned, right? We're all going to pass. That's inevitable. And as a society, we are living longer. And so the chances of incapacity have certainly increased. And so we want to ensure that if an incapacity were to happen, we have the proper plan in place to make sure that decisions can be made for ourselves and also for our minor children. Okay, so what is special needs trust? Special needs trust, and on my screen, I've put up what it is, have a simple definition, and also what I'm describing in this special needs trust is a specific type of special needs trust. It's called a third-party special needs trust. And what is it? It is basically a legal arrangement that is set up for the benefit of your loved one. By having a special needs trust, we're ensuring that our loved one is receiving an inheritance. So for leaving assets behind for our loved ones, they are going to be receiving it in a way that doesn't jeopardize their ability to maintain their eligibility or to become, to be eligible for means tested public benefits. We'll talk more about that a little bit later down in the presentation. And so, sometimes we see, an estate plan that fails to consider an individual with special needs. And the estate plan includes a distribution of an asset outright, meaning it's given directly in the name of the individual with special needs. That's something that we want to avoid because if the individual receives an outright inheritance, that will probably, if not almost a guarantee, that they're going to jeopardize their public benefits. Okay, so we can develop a special needs trust so that we're flowing our estate, the assets we want to leave behind for our loved ones, we're flowing it into the trust rather than outright to our loved one with special needs. Now, it's funded with assets belonging to someone other than an individual with special needs, and it allows for greater flexibility in managing and distributing funds for their benefit. We'll talk a little bit more about that further down in the presentation. Okay, so we need to think about, does your loved one need guardianship? Okay, it's important to know that guardianship is it is something that could be necessary. It is something that we look at only when necessary. We always want to implement the least restrictive alternative to guardianship. So when we are thinking about whether our loved one needs a guardianship, where do we start? So this is something we need to be thinking about as our loved one approaches the age of 18, and we need to be thinking about whether our loved one has the decision-making abilities to make essentially, major life decisions. So talking about, health, medical health decisions, decisions regarding education, okay, financial decisions, okay. If they need continued advocacy, maybe they have the ability, but they need continued advocacy, then we can consider things like supported decision-making agreements. We have estate planning documents like the healthcare surrogate, the durable power of attorney that can be signed, and that's a way that we can give someone else the ability to make these major life decisions for our loved ones. And if these options are not appropriate, then we can consider guardianship. And when we're thinking about guardianship, we really want to think about the least restrictive alternative. And in Florida, we have what's called guardianship advocacy, which is an excellent option if your loved one is going to need a guardianship. It's one where we can preserve a bunch of rights for your loved one, and it promotes the preservation of human dignity because there is no evaluation committee that's required, and I'll talk a little bit more about that further down in the presentation. Okay, so let's go into public benefits. So when we're thinking about public benefits, it's important to be thinking about them in two ways. They're really broken down in two ways. We have what are called the means-tested public benefits, and we have entitlement-based public benefits. What does that mean? So a means-tested public benefit is a benefit that is only available to individuals that meet certain requirements. There's a financial or an income component to it, and also there's an asset component. If they, if they meet the criteria, then they will be able to take advantage of means tested. So it's based on a financial. Okay, so what are the means tested public benefits that are available? There's a variety, but I think the ones that are important to highlight in this presentation are SSI, which provides a stream of monthly income to the individual with a disability, and Medicaid, which provides a healthcare benefit to the individual with special needs. Okay, so what about entitlement public benefits? So these are benefits that are not based on a financial need, but rather they're based on your entitlement to the benefit because you've contributed to Social Security, you've been working, and based on a specific formula. Once you've reached a certain amount of time that you're working and contributing, you become entitled to certain benefits in the event of a need for them. And so we have the two that I think are important to discuss here are SSDI, and we have DAC, that provides a stream of monthly income. And when we have Medicare, of course, which provides a health benefit. So let's talk about the stream of income. So I have up on my screen the two categories of streams of income that I want to talk about. The first one is the disabled adult child benefit, and then we also have the supplemental security income. So for the disabled adult child benefit, this is a benefit. It's a federal program that provides monthly payments to an adult based on their parents' Social Security earnings. So this is available for an individual with special needs, and it is an entitlement-based benefit providing a stream of income that's based on their parents' Social Security earning record. Now, there are certain triggering events that will allow an individual to be able to begin receiving this benefit. Then we have supplemental security income, or SSI. SSI is a stream of income benefit. It is based on a financial need. It's means tested, and it is a federal program that provides monthly income to the elderly, blind, disabled individuals who meet certain income and resource limits. Okay, so let's talk about that a little bit deeper. Okay, so what is SSI? What is it required, and what is the benefit? Okay, so in 2025, the federal benefit rate is $967. SSI is meant to be used, it's to provide a stream of income for shelter. Now, most people understand that $967 is not going to be enough to provide for shelter. Okay. However, the reason why SSI is so important, there's really two major reasons in my mind. Number one is that if you receive $1 in SSI, you receive full Medicaid coverage in Florida, which is huge. That is huge. We want that Medicaid coverage because we want our loved ones to be able to have access to that health benefit for many reasons. Not only is it an important benefit to have for protection of health, but also it's going to help preserve wealth. Okay, when we're talking about special needs planning, because you're going to be receiving this Medicaid benefit, and so other assets and other things that we're leaving behind for our loved ones isn't going to be used to be paid for this. We have a healthcare benefit for that. All right. So some other things to discuss that I've put up on my screen. We talked about in order to qualify, there's an income test and there's also a resource limit. So the individual, if it's an individual, they cannot have access to resources in excess of $2,000. What is a resource? Basically a resource is anything that can be converted to cash or cash itself. So, a bank account, investment accounts, stocks, bonds, real estate. Um, Now, there are some exceptions to the resource limit. So you can own one home, okay? Household goods are an exception. Personal effects are an exception. You can have one car, one vehicle. That would be okay. That's not a countable resource. Okay, so you can have, the home can have, a large entertainment system, and that's not going to be something that is going to be counted against them. The income limit in 2025 is 967 for the individual. And, there are some other things to think about. So there's something called in-kind support. So as I said, SSI is designed to provide for shelter. If the individual is receiving support for payment of shelter, okay, so kind of the things that we talked about regarding housing. If someone's assisting with paying the rent or the mortgage or property taxes or anything like that, and they're receiving SSI and they're getting that support, that in-kind support, then there is a reduction in the benefit of 1/3. And so we'll talk about how we can use an ABLE account to be able to ensure that that 1/3 reduction is avoided. Now let's talk about the disabled adult child benefit. Okay, so this is another stream of income benefit that's available. It is for an unmarried disabled adult over the age of 18 whose disability occurred prior to the age of 22. They can actually draw on the work history of their parents in 3 triggering events. One being that the parent passes. The other is if a parent retires and then begins applying for Social Security retirement. And then also if a parent becomes disabled and starts receiving SSDI, or Supplemental Security Disability. So when does this happen? So if the parent is still living, the DAC benefit, the DAC benefit is 50%. When the parent has passed, it's 75%. In the earlier slide, I had mentioned 2 reasons why I think SSI is important. I mentioned one, I didn't mention the second. I always tell clients if they can apply for, if they're once their loved one turns 18, try to get them on SSI, get that documented that they qualify for it and that they meet the requirements for SSI. Because if they do that, then and they do that prior to the age of 22, it's now been documented. And so later on in life, when they try to apply for this disabled adult child benefit, we already know that they qualify with that age 22 requirement because they've been qualified for SSI. Sometimes, if you wait to do it after the fact, it's very difficult to try to qualify for this. You have to show that the disability occurred prior to age 22. You'd have to go back in time. If you have SSI already, you've meet the criteria. So let's talk about health coverage. We've got means tested and entitlement based. On the left, I've got Medicaid. Medicaid provides coverage for medically necessary services, hospitalizations, prescriptions, covers long-term care. And as I said, if you earn $1 in SSI, you receive full Medicaid coverage. Medicare, that is entitlement based, and it provides medical coverage. If you are on, if you receive the DAC benefit after 2 years, you become eligible for Medicare. So let's go on to special needs trusts. We'll talk about these in more detail. Okay, so on my screen, I have first party SNT or first party special needs trust, and then third party special needs trust. You may be familiar with these terms, you may not, but it's important to know what they are and what the differences are. So when we're talking about first party special needs trust, This is a trust that is designed to be able to hold the assets of the loved one, of your loved one with special needs, in order to ensure that they can maintain their eligibility for their public benefits. So, when do these come into play? These are important when we have a situation where maybe there was improper estate planning done, and suddenly a loved one with special needs is receiving an unexpected inheritance. So they're about to get an inheritance that is going to throw them off over that resource limit that we talked about of $2,000. And that's going to make them ineligible for their public benefits. But because they're receiving this asset, because they're receiving this inheritance, it belongs to them. And so since it belongs to them, it is first party, and it has to go into a first party special needs trust. Also, if there is a lawsuit and they're about to receive a large settlement, okay, we would put this in a special needs trust. We also, depending on the situation, if the individual with special needs is going to be continuing to receive child support payments after the age of 18, okay, that is their money. We need to consider maybe putting that in a first party special needs trust. What about a third party special needs trust? Well, third party special needs trust is really what we're looking at when we're talking about developing a special needs plan. So it's something that we incorporate as part of our overall estate plan. And what we do is what I sort of mentioned earlier on is we're designing this special needs trust so that when we are creating your estate plan, we are ensuring that when we are passing down our assets to our loved ones, we are flowing it into the third party special needs trust and not to the individual directly or outright, so that we can ensure that they maintain their eligibility for the means tested public benefits that we discussed. Now, as I mentioned, it's not just about public benefits. Third party special needs trust, special needs planning. Yes, special public benefits is a large component, but that's not what it's all about. With a third party special needs trust, we're doing much more than that. We're life planning. Okay, we're putting in there legally binding instructions concerning your loved one, right? We're documenting our loved one's desires, what they love to do, right? So we can put in there things that are important to families and important to the individual with special needs. So things like ensuring that the money that is in the third party special needs trust is going to be used for things to promote that life that we want for our loved one to live, right? So we can put in things in there such as the trustee using trust money to be able to spend it on going on vacation, right? Having the individual go on vacations. Um, maybe they love participating in cultural events, or they love participating in certain sporting events or attending sporting events. We can document that. We can put in there that we want the assets in the trust to be able to be used to create that life for our loved one with special needs, so that they can not only have not only so that it promotes their independence, but also so that we are creating a life that's not solely reliant on public benefits, right? Because when we're talking about developing a special needs trust, we're doing it in a way so that we're not, supplanting, right? We're not supplanting the public benefits, we are supplementing it. So this is money in addition to the public benefits. Preserves the eligibility for SSI and Medicaid, and then we can appoint a lifetime management team. Okay, so that's another concern families have, right? It's who is going to be, we've put this trust together, the assets will flow in there when we pass, but who's going to be involved in our loved one's life when we're no longer here? We're going to have a care manager involved. Are we going to have, different family members that we want to be involved to ensure that the trustee of the trust is doing what they're supposed to be doing? So we can really design not only the way that the money should be used, but also we can put a team of individuals that are going to serve as the continued advocates for our loved one with special needs. Some more things to highlight about a third-party special needs trust. We can name a trustee. The trustee is going to be the person that's going to be responsible for administering the assets in the trust. Okay. We can appoint the advisory committee, which could be a good check and balance, sort of what I mentioned just moments ago. It's not just the trustee. We want to make sure that we're putting people there that can, make sure that trustees doing what they're supposed to be doing. Okay. And so it is, if the takeaway that I want everyone to really get from this is that it's not just about public benefits. It's really about designing that life for your loved one that includes public benefits, but promotes independence and promotes the ability to have a life that isn't solely reliant on it. Public benefits, I should say, are crucial, and they're crucial because they're there. They're there for your loved one to take advantage of, and it's important when we're talking about access to health benefits, and also preserving wealth, because by having access to these public benefits that are out there, your loved one is going to be able to take advantage of that, and then the assets that they're receiving from the inheritance that you're leaving to them can be used for other things, right? We're not using that inheritance to fund healthcare and things like that when there's a public benefit out there. So it acts as a great way to preserve wealth. Now let's talk about some arrangements that are common that I think should be avoided at all costs, okay? And these are very common. All right, so what are they? So an outright inheritance. I hope by now you understand that that's something that we should avoid, right? Because if the loved one with special needs receives outright, then they are going to risk, they'll jeopardize their eligibility for SSI and Medicaid, because we have that resource limit, right? $2,000. Anything above that, they're going to lose their eligibility. So do not distribute outright to them. Okay. Now, left in a non-qualifying trust, right? So if we're putting an estate plan together, and sometimes we see this, actually a lot of times we see this, the trust is, there's a trust created, parents have put together a trust, but it's not a qualified trust. And basically it's not a special needs trust. And same problem. It's the same thing as doing an outright inheritance. It is they're going to risk loss of their SSI and Medicaid. This is another one we see, and it's an unfortunate one, and that is disinheriting our loved one with special needs. Right? We never want to do that. We don't. We want to make sure that they are receiving equally. Right? From maybe you have more than one child, one with a special need, one not. Don't disinherit your loved one with special needs. Simply flow it to them in a way that ensures their protection, right? And so that they can, have the life that they deserve. This is another very common approach, and that is, I'll leave all of my estate to a sibling, another child or someone else, and I will talk to them and I will say, hey, listen, when I pass, you're going to receive everything, and I'd like for you to use this money to care for my loved one with special needs. Never a good idea. Although people think it's a good idea, it's not. Put some reasons up on the screen, but I can tell you that, when that happens, a lot of times, maybe at first that family member is all for it and they're willing to do it, but they have their own life, and maybe they have their own children, and they have to worry about. They have their family dynamic, they have work, they have a lot, they have their life that they have to worry about. And so this idea that we will just flow it to another family member to take care of our loved one with special needs, not a good idea. All right, so let's talk about ABLE. As I mentioned earlier, ABLE is definitely something that I recommend to our clients. It is an absolute no-brainer. You need to open one up. It is a 529 savings account. It grows tax-free. There are investment options in the ABLE account. It is a great way to not only provide financially for your loved one with special needs, but I can't say this enough, It also assists in promoting, enhanced human dignity. Okay, because if we're thinking about what is the maximum amount of money that our loved ones can have in terms of resources, and that's $2,000, that cap, because of the wanting to have them be eligible for means tested public benefits. $2,000 is it's really not a lot. Well, how about let's put some money in that ABLE account, right? Because we can put up to $100,000 in ABLE, and that will keep them qualified for SSI, and that money belongs to them. That's their money, right? So we're enhancing their financially, right, of $100,000 that belongs to them. So it's super important. I think, as I said, everybody should get one of these. It's absolutely crucial. Now, it's also great for the overall special needs plan because we use ABLE accounts in conjunction with special needs trusts. How so? Well, special needs trusts, they can pay for a variety of things, but what they can't pay for is for shelter. Okay. I mentioned before that if we have in-kind support, right, then there is a 1/3 reduction in the SSI benefit. So if you were to pay money out of the special needs trust to go towards shelter, well, that would cause an in-kind support reduction. Instead of doing that, what we do is we flow the money from the special needs trust into an ABLE account. And once it's in ABLE, guess what? With ABLE, you can make payment towards things that would otherwise cause an ISM reduction, an in-kind support and maintenance reduction, without jeopardizing the SSI benefit. So you would flow money from the special needs trust into the ABLE account, and then with the money that's now in ABLE, you can pay for the things we talked about that would cause a reduction for housing, the property taxes, the rent, the mortgage. So it's a very, very useful tool in special needs planning. It's incredible. I recommend everybody open an ABLE account. On my next slide, I have different requirements. The disability has to be prior to the age of 26. That's going up to 46 next year. Beneficiary can only have one account. So that's important because if they have more than one account, that second account will actually be counted as a resource. So, if you're, maybe aunt and uncle or grandma, or, and you're thinking about opening one up for, your grandchild or for your niece or nephew, talk to mom and dad before doing it to make sure that they don't already have one. As I mentioned, excellent tool for special needs planning because of the benefit of being able to flow money from the special needs trust into the ABLE account to pay for things that would otherwise cause a reduction in the benefit had it been paid outright by the special needs trust. What are some of the things that ABLE can pay for? They've got to be a qualified disability expense. I've put on my screen things that ABLE can pay for, and it's pretty broad, right? Pay for a lot of things, right? Health, education, housing, can pay for legal fees, right? It can pay for a variety of things. Even upon the passing of your loved one, it can pay for funeral expenses. So it's incredible. Absolutely recommend it. I think that this must be part of your overall special needs plan. So definitely, if you haven't done so already, consider opening an ABLE account. All right, so we are going to be finishing up the presentation with guardianship, and I don't want to overwhelm everyone here with all this info. I know it's a lot, but I couldn't talk about special needs planning and future planning without mentioning guardianship. So what is guardianship? Well, you may or may not know, but in Florida, when you have a loved one, when you have children, you are their natural guardian. That's why you're able to make big decisions for them, right? You can make decisions regarding where they're going to go to school, right? Their medical decisions, what doctors are going to see, socially, what social activities are going to be participating in. You get to make all of those decisions because you are their natural guardian. Now, when your loved one turns 18, natural guardianship ends, and your child receives all of their rights, which is an amazing thing. We want them to have their rights. Now, there's a common misconception that, well, if my loved one has special needs, then I can continue to make all of these major life decisions for my loved one. Of course I can. I'm mom, I'm dad. Of course I can make these decisions. And in actuality, no, you cannot, right? Once they turn 18, they receive all of their rights. And we want them to have rights. We want them to have these rights. The issue becomes, you know, if your loved one is unable to safely make these major life decisions and they need to have continued advocacy beyond the age of 18, then we need to be thinking about alternatives to guardianship and then if necessary, guardianship. So what are some of the alternatives? I mentioned them briefly, but we have supported decision-making agreements. We have healthcare surrogate. We have the designation of a healthcare surrogate, and we've got the durable power of attorney. These are great alternatives to guardianship, but it's unique to the individual, right? We have to make sure that the individual with special needs can legally sign these documents, and that's an analysis that we need to be clear on, because if they can't, then we need to be thinking about guardianship. And within guardianship, we also need to be thinking about preservation of rights and human dignity. So we need to be thinking about what is the least restrictive approach to guardianship. What are the different types of guardianships that are available in Florida? All right, so let's talk about that. Guardianship. So I have on my screen the, generally what are the different types of guardianships that we're thinking about when we're talking about continued advocacy after the age of 18. So the first one on my screen is plenary guardianship. That is the most restrictive type of guardianship. And that type of guardianship is one that we want to try to avoid if at all possible, if it fits our unique individual circumstance. The reason for that is because plenary guardianship involves things that really are, if we can avoid, we want to. Plenary guardianship involves the removal of all of your loved one's rights and then delegating only those rights that are delegable under Florida law to a guardian. Okay. Um, the reason why we want to try to avoid plenary if we can is that, well, first thing that I mentioned, right? We're removing rights from someone, and we don't want to do that. We want to preserve rights. We want individuals to maintain their rights, even if there is a low likelihood that they will exercise that right. It doesn't matter. We want them to have that right preserved. Okay. Um, but not only that, when we're talking about preservation of human dignity with the plenary guardianship, there is an evaluation, a medical evaluation committee that goes through a process of assessing your loved one and making a determination as to whether they are should be found legally incapacitated. Well, why are we going to do that if we have a history of the diagnosis? We know that our loved one has a special need. Why put them through that? Sometimes it is necessary, but if we can avoid it, let's do it. Let's avoid it. Thankfully, we do have an alternative to plenary guardianship in Florida. Then we have limited guardianship. Limited guardianship procedurally is the same as a plenary. However, we are preserving rights. And so as long as the individual maintains at least one right, then we're in a limited guardianship. And then finally, we have guardianship advocacy. And guardianship advocacy is the guardianship that, as a practitioner, I'm always looking to see if it's an appropriate fit, even in what some may consider a severe case. Doesn't matter. We want to look at guardianship advocacy. Why? Well, because guardianship advocacy at the forefront has the preservation of rights. So we're looking at preserving as many rights as possible with the individual. And also, there is no evaluation committee process. So the individual, if they meet the criteria of guardianship advocacy, there's a statute in Florida that governs guardianship advocacy, then we want to look at it as a least restrictive alternative to a plenary or even a limited guardianship. I will also add that it's only available to individuals that, as I said, qualify under the statute. The diagnosis has to be under before the age of 18, and it has to be attributable to an intellectual disability. It's all outlined in the statute: autism, Down, cerebral palsy, Prader-Willi, and Phelan-McDermid. I think I've named all of them. So if your loved one needs a guardianship and they qualify under the statute, definitely advocacy would be the least restrictive type of guardianship that we should be looking at, if guardianship is even necessary at all. Okay, so why should we put together a special needs plan? I have put up on my screen, I've just bullet pointed everything that we've talked about and highlighted today in a bullet form, right? So we're going to provide financial security for our loved ones with special needs, but not forgetting that those public benefits are out there for them. We want to leverage those public benefits because it's going to preserve wealth, and it's going to give them access to systems of a stream of income, but not only that, access to health insurance. Okay, but it's not just public benefits planning. I'll say that 100 times. It's not just public benefits planning. It is life planning. We are getting to document that team, that management team. We're putting together a team of individuals that are going to continue to promote a system of advocacy for our loved ones with special needs. We're planning for appropriate housing. We're letting everyone know what's acceptable, what's not acceptable. Okay, and we're doing all of this so that we can promote independence for our loved ones with special needs while not risking their eligibility for public benefits. When we prepare these special needs trusts, parents love, they light up when we get to put in there all of the different things that we would like the trustee to use the money for. I mentioned some of the options, some of the things that we've done in the past, trips to Disney World, trips to the beach, money to, participate in different organizations that, certain individuals love participating in. So it's really just a great way to document all that and let the trustee know that, hey, we want our loved one to continue to have this life, and we want to have them have that life that they deserve. Finally, when should I start? The sooner the better. So why? Well, if you've done an estate plan and you haven't implemented special needs trust, you got to do it, because if your loved one inherits outright, they're going to risk their eligibility for public benefits. When we do these things, I know sometimes they can be hard to think about, but when we do them, guess what? We have peace of mind, because we do it and that's it. It's done. It's been resolved. Now we've got a life plan for our loved one, right? We talked a little bit about incapacity. What happens if we become incapacitated? Who's going to step in and make decisions for our loved ones, right? Well, we do that. We plan for that. Even in guardianship, a lot of times we have questions about, well, I'll be the guardian. I'm mom, I'm dad, I'm the caretaker. I'll be guardian. But what about when I pass? Who's going to come in next, right? So we can plan for that. We can put what's called a standby guardian, right? So, if your loved one is way younger than 18 and we're not thinking about guardianship yet, that's fine. But we still need to be thinking about incapacity planning. Something were to happen to me, who is going to step in and be the guardian of our loved one, who's going to be able to be making those financial decisions. Guardian if we pass, right? We become incapacitated, who's going to have the decision-making rights for ourselves and for our loved one. And it plans for the foreseeable and unforeseeable future. And so that's why I, highly recommend that you put together your plan, begin developing your plan, work with a financial advisor that's well versed in the special needs community, so that you can ensure that you're getting that peace of mind and you're providing for your loved one beyond your own life. And so that concludes our presentation. Thank you again for having me. Appreciate everybody's time. That's our information up there. If you have any questions, you can scan the QR code, follow us on Instagram. Our phone number is there, and you can certainly email us at info@aguilapa.com. Thank you, everybody.
Thank you, Carlos, so much for presenting a ton of information. I don't know what your afternoon looks like, but we do have we were able to answer 51 questions so far, and 39 still open. But don't know if you have about 5-10 minutes for some Q&A, Carlos, or do you have somebody
Sure.
banging on your door?
Well, I did have someone bang on the door, but I'm okay. I'll stay. Absolutely.
Okay, okay.
Happy to stay,
We'll
John.
take about 5 to 10 minutes because I know there's a ton of questions, and probably one of the biggest questions that I hear and that I saw is whether it be a trustee or a guardianship situation to where you're starting to plan. However, you're more concerned. Okay, we're out of family. We don't have any more family. The parents are kind of the sole caregivers. What do you recommend, or what are those steps for somebody that doesn't have somebody else that can fill those shoes when they pass? Whether that be a trustee for a trust or the terms of guardianship, where would you point individuals?
Yeah, and it's very individualized. That is a common question. We do have a lot of clients that, mom and dad are the only ones living in the US, and that's it. They don't have anybody else. So we got to kind of work through that and see, is there anyone else that could step in? Or maybe we have to consider that we should put maybe a professional as a successor, someone that can come in and manage the assets. Maybe even something like that, because not only are they professionally they handle these sorts of trusts, they know how to do it in a way that doesn't jeopardize eligibility for public benefits. So that could be a way to structure that.
And there's also, from my understanding, there's also professional guardians as well, and that may be a route some individuals have to go through. So let me scan through some of these because, like I said, there's a ton. I know a lot of you have some very unique, very specific questions, and just go back to that disclaimer language we made earlier. You know, everybody's going to have their own unique situation. We always encourage individuals to seek financial legal representation that best can serve them in their unique situation. Um, Let me scroll down here. Um, okay, so somebody said, they have a condo and they want to leave it to their son. Can they do it through a quick claim? Is the best, but that sounds like more of the, hey, we might look at a trust or some kind of planning method.
Yeah, so it really depends, right? Is this the homestead? Is this where they live? Is it a rental property? There's an extra property. I don't personally like, I would probably do a quick claim deed. I would, we're thinking about leaving this property for our loved one, then we want to make sure that I like it flowing into a special needs trust. That would be the
Mhm.
best way to do it.
Okay. Another question about a special needs trust, right? We have the funds to start a trust. Should we go ahead and start funding a trust?
Again, depends on the situation, right? You can go ahead and start funding it. Some things you need to be thinking about, if you're going to be funding it, how much money are you putting into that trust, right? If you do a third party special needs trust and you start funding it right away, it's part of your personal estate, your personal tax estate. So you got to pay taxes, and um, that that may be a barrier for other people to contribute into that trust, because maybe mom and or grandparents or aunt and uncles would say, don't fund that trust with assets because technically that money would belong to the parent that created the trust. So maybe we put in some triggering language in there for making it irrevocable. But yes, you can certainly um, fund it right now if you want. Absolutely.
Okay. So this is a question as you tackled a little bit about guardianship and the different levels. Can an individual move between the levels? So if somebody went forth and did the whole planetary guardianship and got the full shebang, but then realized, hey, maybe limited or even guardianship advocacy is a better case. I'm assuming they're going to go to the courts and that kind of thing. But comments
Yes.
on that?
Yep. It's something that unfortunately we've seen a lot, whether it be lack of education or attorneys that they just don't get it. They've put in a plenary where they really shouldn't have, and I don't know how the evaluation committee approves it or why they approved it. But yeah, we go through a suggestion of capacity process where we can get rights restored, and procedurally we can ask the judge, "Hey, judge, they don't need plenary. Let's get them to advocacy," and then we gotta make sure judges are educated as well.
Yes. That's an interesting question, and I've never heard this actually. So they have a family member with special needs who stopped getting SSDI because they got married. The
Hmm.
wife passed away suddenly, and he still hasn't been able to get back on SSDI. But to me, that's unique because SSDI, it's based on your capacity to work or not.
Right.
Um, yeah, so that's a unique case. I don't.
Yeah, I mean, I would ask, are you sure it's SSDI? It might be SSI. A lot of people
Mhm.
confuse it with all the SS's
Yes,
everywhere,
yes.
right?
Uh-huh.
And then yeah, so there are income and the income and resource limit and all of that is all dependent on individual or married.
Yeah.
I would say, and what I do with in situations like this, I connect our clients with benefits planners that are really well versed in the requirements and the application process, and assisting individuals getting requalified when they've lost their benefits.
Yeah, that's a good one. Kind of answered that one. I'm just looking through. There's another couple ones we can get to here. Um, is there a difference between a medical surrogate and a medical proxy?
There is a difference. There's a healthcare proxy that's
Yeah.
followed, there's a Florida statute on that, right? These are
Hmm.
usually done in emergency settings.
Yep.
Healthcare surrogate, can be used in an emergency setting, but we're doing it preemptively. And usually the healthcare issue, like who's going to be making the medical decision, it's really not really so much so in the emergency situation because we can get that medical proxy done. It's
Hmm.
more for the more common things like, oh, I haven't gotten this guardianship yet. I don't have healthcare surrogate, and now the doctor is saying I need to be the guardian to be able to do this procedure that may require anesthesia or something like that. That's usually where we see the issue.
Yeah. Yeah. The medical proxy to me is that's the kind of listing they have, right? Where if a health surrogate hasn't been in place, it kind of goes, okay, here are the people in order that can make a decision for their
Exactly.
medical needs in the case of an emergency. So yeah, definitely be preemptive with the surrogate. Um, so a lot of questions about costs of setting up a special needs trust and who to talk to. Is this something I can do on my own? I'm not gonna touch that, right? Because you probably would echo the same, Carlos. Is it just depends on your unique situation, the complexity of it, how many people are going to be involved in the trust. Are we talking multiple inheritances? It's the assets. I mean, there's a lot to it, right? At the very minimum, it does require an attorney, right, to set one of these up and to get passed and treated correctly, especially if somebody's already on Social Security benefits, because I think there's a process for them to give in their rubber stamp of approval as well, which can be interesting. So,
That's
anything
right.
you want
But
to add?
yeah, you're right on all that. But something that I forgot to mention that I think is worth mentioning now is that guardianship advocacy, so long as there's no assets involved, you actually don't need an attorney to do guardianship advocacy. Okay, something that may be appropriate for the person. Maybe they're savvy, they feel comfortable doing it, or sometimes, actually, a lot of times, we help with families setting up the guardianship advocacy, and then once we have it set up, we get to be removed. They don't need to rely on us anymore as the attorney, and they statutorily are allowed to continue guardianship advocacy without having a lawyer assigned or a lawyer of counsel or of record counsel, which is different than the other type of guardianships. You have to have a lawyer if we're
Mhm.
talking about plenary.
Yeah, yeah, and that's actually the next question on the list was the advocate versus that limited guardianship. And it says, can a person with a guardian advocate sign documents for themselves? So,
Can the guardian, can the individual that is has a guardian? Okay, so the
yeah.
advocate, the advocate can sign on, will be able to sign on behalf of the individual that's in a guardianship advocacy. The individual themselves, right? No, they depending on what we're talking, what right they're exercising. No,
Hmm.
that's the whole thing, right? We're
Yep.
protecting them from a bad decision. When we're talking about like a durable power of attorney or a health, even a healthcare document, they maintain their right, to make a decision. We're just giving
Hmm.
someone else the ability to also make a decision. So we got to think about that. If the individual, makes a bad decision and you are the agent under a power of attorney, well, you can't go back and say, "Hey, but I'm the power of attorney. I'm going to undo that." You can't do that. In
Yeah.
advocacy or in the guardianships that we're talking about, then yes, you can have that correction.
Okay. Here's kind of a dual able slash special needs trust. So, is it worth setting up a special needs trust for $100,000 inheritance, or is it better to put the money in an able account? All right. So I typically I tell individuals, able's restricted, 19,000 per calendar year can go into the account.
Right.
more if the individual is working. That's usually not the case, but that can be the case for some individuals. And then you have, the other $71,000. Is there a spin down plan? Are you looking maybe at like a pool trust where it's lower fees, lower structure? So that's
Yeah.
typically where I see individuals go to. But I'm assuming the same, Carlos.
Yeah, no, I agree. Those are all things we need to consider, and it is very, individualized. But yeah, consider
Mhm.
pooled, and yeah, and you have to consider that 19,000, that max contribution.
All right, let me scroll down here. Um, this is another Social Security question. If somebody's on SSI, husband and wife are both on SSI, can they each own a car?
Can they each own a car? That I know you're allowed to have one car. I don't know if if
If it's a
that
family car, yeah,
yeah, I'm not
I
quite
don't know the answer
positive to
either.
be honest.
Yeah, yeah, that's a good question because I know you could have one home, right? So they both each could have a home,
Correct.
one account. My assumption. I mean, I don't know. We'd have to go and consult the good old Palms manual,
Yeah.
or Google for that one. uh, all right. Can a special needs beneficiary disclaim if they get a surprise inheritance?
Yes, but it's still counted against them.
Yeah, yeah,
Okay,
yeah,
so
yeah.
yeah, that's not a
It
good
would still
that's not
count
a
as
good
income for
plan.
that month, but
Yeah,
yeah, it's still, yeah,
yeah,
yeah. So
that's not a good plan.
not a good plan. All right, let me see if there's any other ones in here we could tackle real quick. Um, we talked a little bit now. There's quite a few questions on the ABLE account if an individual passes away. I usually, one of the things I tell individuals, the goal of the ABLE account is to be a spin down account, right? You're putting it for some kind of goal. Like, hey, we want to save for X. We want to go on those Disney trips. We want to have this person live as independently as possible. So we're going to offset some of their housing costs with the ABLE account. But typically, person passes, you can still pay funeral and burial. If there's any funds left over, then it would need to go to the estate of the beneficiary. Now, their estate may be subject to Medicaid recovery if they're over the age of 55. So I usually stress people, hey, if you have an ABLE account and that individual is getting close to 55 or older, you really need to start going, okay, we don't want to have hundreds of $1,000s in the ABLE account potentially. You want to have some kind of goal method of where you're going to be spending and utilizing those funds, because ABLE is an acronym for Achieving a Better Life Experience, that, and you can't achieve that if you've passed. So
Right.
let me see if I get a couple more in here. And thank you so much, Carlos. You're going to have to bill us extra for this. Um, uh, questions about funding ABLE accounts with SSI? Yeah, so you could direct deposit your Social Security funds directly into ABLE account. If you're on SSDI, be wary, because if it's more than that 947, because I think some people can get 13, 14, 1,500 a month, it could get in a situation where it gets rejected if it gets close to that $19,000 limit. So once again, depends on your next step. So we'll end with this question because I think this is good. Carlos, so people are interested in learning more about special needs trust. They want to get started. Where do they go?
Well, I mean, if they're interested in finding out more, we certainly love educating. So you can certainly reach out to our office, and we can definitely provide you with information and resources about special needs trust, and also, guardianship and alternatives.
Wonderful. And we will make this presentation available. I think there's a way, if you're okay with that, we'd love to share this resource out to everybody that attended. Um, and want to thank everybody once again for their time. I know we ran a little bit over. I know a ton of you still had outstanding questions. We'll do our best to kind of reach back out if we are able to. But once again, just a reminder, everybody is unique. I did want to highlight, if you don't have an ABLE account, that's a greatest way to get started. Takes 10 minutes to open. And best yet, if you open an ABLE account before the end of June, we will put $50 into your account to help you get started saving and achieving a better life experience. But once again, Carlos, thank you so much for your time today. Hope you have a great rest of your day.
Thank you for having me. My pleasure. Take care, everybody.